Thank you for joining us here on NCN as we bring you important information in relation to some of the things that have transpired today in our court system. With me is King's Counsel Darshan Ramdhani, who is Special Prosecutor and will be giving us an update in relation to these matters. Mr. Ramdhani, thank you so much for joining us.
Yes, thank you for having me here. I do believe that it is important enough for us to share the events of today's hearing in the court. As you know, the last time we spoke, I'd indicated that the matters were those criminal charges were scheduled to come back in court today before the magistrate. We came into court today at about 1 o'clock. The defendants were all present except for one. We proceeded to begin our case management in relation to the matters. The basic and important things that are to happen next was essentially two things. There were two things to be determined, and the prosecution brought this to the attention of the court. One was that there was that outstanding issues for the court, on the side of the court, to determine whether all the proceedings, the charges were going to be heard together. You'd recall on the last occasion, I did say that applications had been made since last year for the several magistrates to bring them all before one magistrate and for them to be tried together. And it so happened, and as I indicated then, that they were all, most of the charges except for one were before magistrate daily, and the summary mode of trial had already been determined. So in my view, it was necessary for the court to formalize that and give the indication that we were going to try all the charges together. So the prosecution raised that as an outstanding issue for the court to resolve, because we had made that application a long time ago.
Yes.
The more important issue, though, arose in terms of when these matters would literally start to be tried. As I indicated to you on the last occasion, the prosecution are ready, and it is now a question of what dates are going to be put to begin to take the first witness. So it became apparent that many days would have to be set aside to try such a matter. As I indicated on the last occasion, these matters were going to take quite a bit of time of the court resources. When you begin this, you could not try these kinds of cases and adjourn today to come back next week to take a half day of trial. As we said, we had disclosed over 140 statements. We have close to 100 witnesses. We have tons of documentary evidence. We have a number of video evidence that have been disclosed to the other side. You've seen the truckload of evidence that was disclosed last year, I believe it was. And so the prosecution, the court, the defense became engaged in this process of rationalizing how a single magistrate sitting, having to deal with every other matter. The magistrate reminded us that there are more the cases being tried before her preliminary inquiries, serious matters, people are on remand, and so a magistrate could not decide to give up those matters in favor of one. I remember saying to you that such a power exists in the chief magistrate and the chancellor. If you recall from what we said that last year, March, we had written a letter to the chief magistrate, copied to Magistrate Isaac and Magistrate Daly, for considerations to be given, not only to put the matters together, but to have a single magistrate assigned to these matters. So this afternoon's proceedings in court, this issue of how we were going to approach the actual trial arose, and the chief magistrate never determined that issue. And I do believe, from looking and listening to Magistrate Daly today, that the magistrate herself was, I think, properly concerned how we were going to start, allocate days, and complete this matter. We suggested to the court that this matter was likely to take months, possibly years. The defense said, offered a suggestion it might take as much as 4 years. I wasn't even clear then that whether the defense meant if we went every day, we would take 4 years. But even if we went every day at this matter, it would take a considerable time and would possibly go over a year, because you have 9 defendants and there would be a lot of cross-examination, I suspect testing the evidence, which is a part of these matters. We can't not have that. These are incidents of a fair trial. And so the magistrate recognized very early in our attempt to case manage this matter today. And this is part of case management.
Yeah.
We have cases and the court is managing how the matters will begin to be tried, what, if any, issues are outstanding. And so these are the matters that the prosecution wanted to be case managed. The defense didn't raise any particular issue beyond the 2 issues we discussed here. Their contribution, of course, was that the magistrate had no power to even consider whether the chancellor should be involved. And so the suggestion became that if the chief magistrate did not make a determination, and now the matters are before a single magistrate who did not have the power to determine that she can give up trials of other matters and try only this case, then perhaps we suggested that the magistrate consult with the chief magistrate and the chancellor. It became apparent to us that the court was more comfortable with this coming from the prosecution, being that where we were. Remember, this is in the context of us applying since last year to the chief magistrate to get these matters to be tried by a specialist magistrate,
right,
a magistrate dedicated to this case. So whilst the prosecution remains ready, we have to be practical. We recognize that a single court sitting now dealing with other matters, and this is something that must have engaged the minds of the defense. They must have understood that. Remember, we have gone 2.5 years listening to application, the prosecution trying its best to get the matters on with, but various objections, various applications are being made. I suppose you will even hear now that the prosecution is not ready. You'll probably even hear that now. But this is where we are, and the court adjourned the matter today to the 25th of October to report on the outcome of our plea to the chancellor, because the court recognized it does not have this power to determine that the court can give up the other matters and try this matter as a dedicated court. So I think the court sees with these cases right now is approaching this matter in the best possible way. This is the best possible way, because otherwise, if this court is to commence these matters, having regards to the fact that this court is dealing with other cases, one can understand the agony that this court is going to go through. And not only the court going through the agony, the defendants themselves, the public. The justice is a balanced thing. It must be balanced. And it must be fair to the defendants. It must be fair to the public, because it is the interest of the public that crimes are prosecuted fairly and a just outcome is arrived at. Now, you can't have that if you have no trial. And we are at that point. So we can begin this badly or properly. And I believe the magistrate has recognized that the proper course would be to have this particular issue determined as to whether a court is going to be put in a place where it will have to deal with every other criminal case that it has on its docket, or whether a court will be properly authorized. And this is not something that the prosecution decides. Remember, we have been pressing these courts for a while.
Yeah.
So it is not something that we are at the point of case managing, and we are managing these cases. And these were the things that we addressed in court. I didn't hear the defense raise any other issue except, as I said, these 2 issues about whether these charges were going to be heard altogether, which is what we raised, and whether a particular magistrate was going to be able to dedicate a lot of time, consistent time, to these matters, so that the defendant's agony, the public's agony, anxiety can be managed, and we can get to the end of these charges within a reasonable time.
Yeah. Just so we're clear, so on the 25th of October, the court will come to a conclusion on whether or not these matters will be heard together and by a specialist magistrate, or?
We suggested to the court, well, I'll answer it this way. We suggested that the court itself should engage, as I said, the chief magistrate and the chancellor, because those persons, those judicial officers, are the ones who have the discretion and authority to make a determination as to whether or not a dedicated court is going to be appointed to sit and hear these matters to the exclusion of other matters. The court was more comfortable that the prosecution initiate that. Now, it was raised by the defense, well, why didn't the prosecution initiate that before? Well, let me say this very clearly, which we brought out in the court, that we were before courts that had the power to determine this. The chief magistrate had a power to determine this. And we raised this issue in writing since last year, March, when we copied the defense and all of the magistrates and asked for this issue to be determined. So since last year, March, this point was raised for us to get this determined. Where we are now, and what is going to be heard on the 25th, is a report is going to be given to the court. Perhaps the court itself may tell us that instructions have come from the proper judicial officer, the chancellor, the chief magistrate, that number of days are going to be set aside to the exclusion of other matters, and that this matter will be dealt with, and here is a date for us to start. Yes? Or that a particular magistrate will be assigned, and that magistrate is Magistrate X to deal with this matter. So that is what is going to happen. So we are going to make, on what we discuss, the prosecution, of course, will make, write formally to the chancellor, now that the chief magistrate has not made that determination, and ask the chancellor to consider the factors here. The factors here being, these are significant, important cases of national interest. They involve serious criminal charges. They have a lot of witness, close to 100. There's a lot of evidence. And when these matters begin, they're going to consume considerable resources of a court, and they're going to last for a considerable length of time, and which public attention is going to be drawn. It will be a point of discussion, perhaps on a daily basis. And it would be in everyone's interest, the defendants, their families, the public at large, the rule of law, for these matters to be determined quickly. Yeah. And so it is hoped that when the formal communication goes out, I am here just after the hearing today, that a favorable consideration is going to be given to the request, and the assistance is going to be given to the court that we are before, so that the matters can be dealt with properly and quickly.
Yeah. Mr. Ramdhani, thank you so much for taking the time to have this discussion and open up the floor for this information. Thank you so much.
Thank you for allowing me to be here today.
Definitely. You've heard from Special Prosecutor Darshan Ramdhani, who has been placing special attention on the election-related cases and the election fraud cases that are currently before the court. My name is Shaquan Gill, and I'm saying goodbye for now.